So hello everyone, thank you very much for joining us today. Thank you to Caitlin and Alfina for inviting myself and HCR Law to present today. For those of you who don't know, obviously Caitlin said that HCR Law is a sponsor of NorCA. We are a full service law firm. And we provide support to all types of businesses and individuals, but in particular we have a healthcare department which covers all disciplines. My own is healthcare regulation, but we have corporate employment, immigration advice, real estate. So hopefully all the types of issues that yourselves might be incurring. So Caitlin and Alfina asked me to speak today in relation to the Care Act. Now, as you will all be aware, the Care Act is a very big piece of legislation. But what I was asked to specifically concentrate on was, I understand that some of you are having issues around local authorities moving residents due to funding and costs rather than actually putting the service users' well-being first. And, NorCA is obviously working with providers to wanting to empower them to challenge local authorities where it seems that they're making decisions based on money rather than those of wellbeing principles and person-centred care. Now, I would just want to say right at the beginning that this is going to be a very high-level overview of the Care Act in relation to these particular issues. The Act is very detailed. There are lots of nuances. So this is about high-level principles, which, where necessary, we can go into a deeper dive if required. I think it's also important just to clarify that as providers, you cannot make direct challenges on behalf of service users about wellbeing principles. So that is for the service user. Any issues around funding really come down to contractual matters or judicial review challenges. But if you understand the wellbeing principles, it may well assist you to support service users to get appropriate assessments and funding. So it's probably worth us starting off looking at what the actual framework is for this particular area. So, of course, we've got the Care Act itself and its subsidiary legislation, which is made up of the assessment regulations. This governs the provision of adult social care in England and is it codified the legal framework. It places personalisation on a statutory footing for the first time and sets out responsibilities of English local authorities for adult social care. So again, only applicable to those in England. We also have the Care and Support Statutory Guidance, which, as the name suggests, is guidance, but it gives a lot more details around instructions to local authorities on how to implement the Act. Now, it is in the process of being reviewed, so it is important to keep an eye on it, and it is available on the internet, so you'll always get the most up-to-date version. Now, with statutory guidance, it is considered binding unless there's a good reason not to follow. So, generally taken, you ought to be following it. The very, very first section of the Care Act, Section 1, is entitled Promoting Individual Wellbeing, and wellbeing is the guiding principle behind the Care Act. So the Act says there is a general duty of a local authority in exercising a function under this part in the case of an individual is to promote the individual's well-being. It's fundamental, as I say, that the Care Act places personalisation on a statutory footing, and it's about individualisation. It's not a one-size-fits-all. The Act actually provides a definition of well-being as well. So in relation to an individual, it means that the individual's well-being so far as relating to any of the following. And these are outcomes that must be achieved, or at least one of them ought to be achieved when considering decisions under this part of the Act. So it includes things like personal dignity, ensuring their physical and mental health and emotional well-being, But also of particular importance, again, to yourselves, is control by the individual over day-to-day life, which includes over care and support provided and the way it's provided. We then turn to the Care Act guidance, and as I say, it's very, very detailed, but it does put some meat on the bones to the Act itself. Again, the very first principle of the guidance is about promoting wellbeing, and the wellbeing principle is that which puts wellbeing at the heart of care and support. Now, it applies to all cases where a local authority is carrying out a care and support function or making a decision in relation to that person. But again, just a caveat, it's important to know that the wellbeing principle is not intended to be directly enforceable by an individual, but rather carry indirect legal weight. So where a local authority has perhaps failed to follow the principle, they might be able to be challenged by individuals. But really what the Care Act is trying to achieve or is seeking to achieve is a shift from providing services to meeting individual needs. And of course, meeting needs means that everyone is different and, one size doesn't fit all. Now, the guidance sets out what a local authority must have regard to when exercising its functions in respect of an individual. Now, the local authority must have regard to the following matters. And now these are just a selection of those matters. It's not exhaustive because, as I say, it's a very detailed act. So I've kind of picked out areas that I think are particularly relevant for your situation. There is essentially like a checklist that local authorities must go to, and so it's important for challenges to understand if the outcomes have been achieved and the wellbeing principles achieved. So the very first thing that they must have regard to is they must begin with the assumption that the individual is best placed to judge their wellbeing. That the individual's views, wishes, feelings and beliefs, including religious beliefs, are taken into account. But again, a slight caveat that it's important to note that case law establishes that a person's wishes is not an overarching consideration. They must be taken into account, but it doesn't trump everything. They must also ensure that an individual participates as fully as possible in decisions, and that individual is provided with information and support necessary to enable the individual to participate. So again, this is about decisions being made with the individual, not about them and them imposing it on them. So essentially, no decision about me without me. There are 5 stages to accessing adult social care. You've got the assessment process. You've got, as part of that assessment, identifying whether there are eligible needs. So the Care Act establishes national eligibility criteria, which are set, so all local authorities must follow this. They also have there's then the care and support planning process, followed by the financial assessments and whether any charges should be levied. And then these should be reviewed periodically or whenever there's a change. So when should a service user be assessed? Well, under Section 9 of the Care Act, the local authority has a duty to assess when it appears that an adult may have needs for care and support. So there only has to be an appearance of that they need to have support, and it's a case of they may have needs. So it's a very low threshold that triggers the duty to assess. And at this stage, it's irrelevant what those level of needs might be, or indeed whether they have the resources to pay for care moving forward. The individual must be ordinarily resident in the local authority's area or be present and have no settled residence in order to trigger this duty to assess. When carrying out an assessment, the local authority must involve certain people. Now, as I've said, this is about putting the person at the heart of all these decisions. So, of course, the adult themselves must be involved in the process. Any carer that the adult has should be involved in the assessment. and indeed any person the adult asks to be involved in the process. So this could be, for example, yourselves when it comes to them being reassessed by the local authority. Now, where the adult lacks capacity to ask the question for someone to be involved, then the local authority ought to involve any person that appears to be interested in the adult's welfare. So again, could well be yourselves as providers. Now, as part of the care planning process, the individual is being assessed and they must fulfil eligibility criteria. So that's under section 13 of the Act and set out in regulation. And there are 3 criteria which an individual needs to meet in order to fulfil the eligibility criteria. So the first is that they have needs that are caused by or related to a physical or mental impairment or illness. And as a result, the adult is unable to achieve 2 or more specified outcomes. Those outcomes include things like maintaining personal hygiene or ensuring they can their toileting needs are met. And then equally, as a consequence, there is or likely to be a significant impact on the adult's well-being. The local authority will then consider resources, so anybody below the financial threshold, which I think is just over £23,000 at the moment. And as a result of the assessment, the local authority must then prepare a care and support plan. This is set out under section 25 of the Act. Now, a care and support plan has to include the needs identified, but also consider things like the well-being principles and the outcomes. You know, what does the person want to achieve? It is not purely based on the person's needs. Whether those needs meet the eligibility criteria, which I've mentioned, specify the needs that the local authority is going to meet and how, and then include a personal budget. Now, the local authority must give a copy of that care and support plan to the adult and any other person that that adult asks the authority to. So again, it may be that the adult may ask that a copy is provided to you where those individuals are within your care. Within the care and support plan, the local authority must set out a personal budget. So this is an allocated sum of money that the local authority reasonably believes can meet a person's care and support needs. And because it's a personal budget, then obviously people can use that money themselves to arrange their own care, or then ask the local authority to arrange care on their behalf and pay for it through the budget. The personal budget is a statement which specifies the cost to the local authority of meeting the adult's needs, which is required or it decides to meet, the amount that the adult must pay towards the cost of following the financial assessment, and the amount the local authority must pay. And when establishing the cost to the local authority, they have to give consideration to local market intelligence and the cost of local quality provision to ensure that the personal budget reflects local market conditions and that appropriate care that meets needs can be obtained for that amount specified in the budget. So again, these are all principles that we have to consider when we're thinking about funding for providers in general. Decisions should therefore be based on outcomes and value for money rather than being purely financially motivated. It's important that the personal budget, and important it's set out in the guidance, that the personal budget must be transparent and robust, so it is clear how the budget has been calculated and people have confidence that the allocation is correct. The amount must be sufficient to meet needs and must take into account the individual's reasonable preferences, which should be detailed in the care and support plan. So again, it's not just simply about basic needs, it's about how somebody wants to achieve outcomes, and they need to be taken into account. The local authority must keep these care and support plans under review, as set out under section 27 of the Care Act. These are reviews in terms of a general review, but also on a reasonable request by or on behalf of the adult. So where the local authority is satisfied that circumstances have changed in a way that would affect the care and support plan, it has to reassess. So of particular importance to providers and yourselves will be where there's been a change of need. What you can't do is request a change because your general costs have gone up, but where a service user's needs have changed and that has resulted in increased costs, then that could be a reason to prompt a review of the care and support plans. I think at this stage it's probably also important to specify that there is the ability, or at least the theory, of service users choosing where they live. So this is of particular relevance to care homes. So where they've been assessed as a care home is the appropriate place for somebody's needs to be met, they have the right to choose which care home they live in. It is subject to certain conditions, that being that the accommodation is actually suitable for the person's needs, so you can meet their needs, that the accommodation is available. Obviously makes sense, making sure that there's a bed available in a home, that the provider is willing to contract with the local authority. But then here's the kicker: to do so would not cost the local authority more than the amount specified in the person's personal budget for accommodation of that type. So it must be that it cannot be sufficiently costs significantly more than the amount of money that was specified in that person's personal budget. So essentially, you can't make someone contract with you. It'd be very nice if we could. I also just want to touch very briefly on top-ups, because of course this comes into funding quite significantly. Colloquially called top-ups, really they're third-party contributions. So this is often where, again, this relates back to the choice of accommodation, where a service user wish to live in a particular home, but unfortunately it does cost more than what is designated the sufficient spend to meet the person's needs. So we can enter into third-party contributions, but this must be for something extra or different. So it might be that you have rooms that have beautiful views of gardens, or larger rooms, or there's a cinema, or you serve wine with dinner. It cannot be for the base service of meeting that person's care needs. You cannot have two people paying money towards the base cost. And the ideal position is that the local authority or the ICB, depending on who it is, contracts with the third party, and monies go through the local authority and then paid to the provider. Or again, doesn't happen that frequently. I think it's also important to actually touch on your position as care providers and where your remedies might occur in terms of funding. And of course, that mostly comes out of the contracts which you sign with these local authorities. It's important to think about the fact that social care contracts are likely to last for years. So it's important that the contracts that you have in place, whether that is private contracts with private paying service users or with local authorities, have provisions which build in flexibility, because we know that care needs can change. You've got the care needs on admission and then on an ongoing basis. And as I say, care needs will change, sometimes for the better, but often for the worse. And there is going to be an increase in needs, which requires resources and therefore funding. Now, unfortunately, you don't get to set a contract with the local authority or the ICB. It's very much imposed on you. And this is where some difficulties can often arise. But it's important also to remember that regardless of whether you are being paid enough to do it, you also have obligations under your regulatory obligations in relation to the Care Quality Commission to ensure that you are meeting those needs. So again, I thought it was quite helpful just to touch on very quickly the regulated activities regulations, which I'm sure you will all be familiar with, which relates to person-centred care, and in particular Regulation 9. So you are required to ensure that the care and treatment of your service users are appropriate, they meet their needs and reflect their preferences. Again, referring to preferences, not just a basic care need. And in order to comply with that, you must carry on assessments of the needs and preferences and work collaboratively with the relevant person, that being the service user, and then designing care or treatment with a view to achieving those preferences and ensuring their needs are met. So they are your regulatory obligations under the Health and Social Care Act regulated activities regulations, amongst other things, but it's interesting to see how they tie with similar provisions under the Care Act. So running in parallel, your obligations versus the local authority obligations. When considering your care contracts, it is important to think about how payments can be varied, if at all. So how do you address changes? If you need more staff because the needs have increased, how does that get addressed through the care contract? Who will bear the increase in costs? Because frequently what we see is that those costs land with yourselves as providers. Now, it is important to remember that contracts with local authorities often have a dispute resolution clause, and this is often where you can address issues around costs. Now, again, ultimately, where people cannot agree, the ultimate remedy is to contract elsewhere. And if the local authority doesn't pay fees or doesn't increase fees after having discussions or entered into negotiations, then it might be that you feel that the best course of action is to terminate the service user or the agreement in relation to the service user, because this is a cost that you are bearing rather than the local authority. Although, as I say, there are options in relation to contract disputes, judicial review claims, which I'm going to touch on very briefly in a short while. It's also important for us to refer back to the Care Act in relation to local authorities' market shaping obligations under the Care Act, which comes under Section 5. Now, local authorities are supposed to promote the efficient and effective operation of a market, ensuring that there is a variety of providers to choose from. There has to be a genuine choice for people to choose from, and there has to be high quality services to choose from. Now, the local authority is not to take action that might threaten the sustainability of a market as a whole. And it is specifically set out in the guidance that an example of this is by setting a fee level below an amount which is not sustainable for providers in the long term. Now you can see that at the bottom of this slide I've posed the question in square brackets, like, can this be achieved on the same cost? So we know that local authorities, as a general rule, have a set fee. So if they are asking, or one of their obligations is to ensure that there's a variety of services that are of high quality, question, can this be achieved if they are handing out the same amount of money to providers across the board? In considering their market shaping duties, local authorities have to have regard to fostering continuous improvement. They have to look at efficiencies and effectiveness, and they also have to encourage innovation. They have to foster a workforce where those members are able to deliver high quality services because, for example, they have the relevant skills and the appropriate working conditions, and remuneration must be at least sufficient to comply with national minimum wage requirements. So again, I've made the question, can this be achieved without the local authority actually paying more money? If you're having to cover national minimum wage contributions, NI contributions, provide training to your staff to ensure that they have the relevant skills, that you're innovating in the way that you are providing services, these are all factors that have to be looked at when considering how much the local authority is prepared to pay towards the funding. Local authorities must ensure that there is value for money when they are commissioning services. But it's not just about achieving the lowest cost, but they are allowed to take into account scarce resources. So they are allowed to consider that they do not have an infinite pot of money. This was considered particularly in a European Court of Human Rights Act, which dates back to 2014. So it was before the Care Act came into force, but it has been reiterated within the Act and the guidance that local authorities can take into account their scarce resources. So this particular case, McDonald against the UK, was where a lady had been assessed to have a night carer help her to go to the toilet. She went to the toilet frequently during the night, and she had somebody there helping her. At some point, she was reassessed, and the local authority decided to remove that night carer and provide her with incontinence pads. And she challenged this decision on the basis that her Article 8 rights had been breached. The court decided that whilst Article 8 might be engaged, they weren't in this particular case, and as long as the local authority was actually meeting her needs, they could choose to do it in a more cost-effective way. So in reducing her care package, they could take into account the scarce resources that they had. So it's not an absolute right, but just to emphasize, needs have to be met, but they can be done in a slightly different way to that perhaps would be the preference. As we're talking around case law, I thought it would also be helpful to touch on some recent cases, which I'm sure you will be familiar with. But you will have probably seen the Staffordshire Care Association, sorry, get my teeth in, take Stoke-on-Trent City Council to court. I think it was last year or the year before, sorry, actually not 2024. The council had decided that it was just going to put up its residential care placements by 1.4%, which was the basic minimum that was stipulated in the care contract. So again, referring back to the contract and obviously ensuring that your terms are clear about what is actually covered and where there's flexibility to increase. Now, the Care Association argued that this increase was insufficient and did raise concerns about the potential impact on the care standards and the risk of vulnerable residents being displaced. The court heard the evidence and actually allowed the appeal, sorry, the claim on 5 key grounds. 3 of those grounds are or were that they had failed to comply with the statutory duties under the Care Act and the guidance, that the council hadn't adequately assessed the actual care costs or the inflationary factors such as national living wage increases, and they'd neglected to consider and have proper regard to the actual costs of care and other statutory factors that were either implicit or expressly relevant. So that was great. The court found in the Care Association's favour and they quashed the council's decision and ordered it to reconsider that decision within 28 days, ensuring that it gave proper consideration to the consultation responses, its statutory duties, the Care Act. Now, the council retook the decision, but it remained at 1.4% for the year 24-25. Now, that is one of the problems with the remedy of judicial review, is that the court doesn't replace the decision maker's decision. It simply asks them to retake a decision, making sure that it does so lawfully. So the council retook the decision, apparently lawfully, and came to the same conclusion. However, what has been interesting about this case is that the 25-26 fee uplifts for Stoke-on-Trent has actually increased to between 4.77% and 7.96%. So there really is a thought that the judicial review had an impact in ensuring that, certainly for the future, that appropriate costs were covered. Also of interest, to yourselves will be the Julie Richardson and Banbury Heights case against Oxfordshire County Council. Now, this was a case that HCR was actually involved in. Important to note that it was an application hearing only, but what had happened in this particular case was that there was a private paying service user whose financial resources then actually fell to below the financial threshold. The service user had remained in the home kept meeting needs, and then the care home decided it was wanted to recover unpaid fees from the local authority because resources had gone below the threshold. Therefore, there was a duty to reassess this person and therefore meet that person's needs. The local authority claimed that it should be judicial review. We brought it under a private law claim, which the court accepted. And the court held that once the service user met the eligibility criteria, then the local authority was under a duty to meet their needs. The care home had then met them on behalf of the local authority. So by not paying for those fees, Oxfordshire had actually been unjustly enriched at the expense of the care home. So the High Court upheld that there was the right of the care provider to pursue restitutionary claims for unpaid fees where that local authority had a statutory duty to fund. And those statutory obligations arise out of the Care Act. It reinforces the ability to recover unpaid fees from local authorities in situations where they have a statutory duty to fund but have failed to do so. So where are we with Norfolk? Well, it was quite pleasant for me to read that they had a £30 million increase in 23-24, which was on average a 9% uplift in care fees. I also had a look at their market sustainability plan, which was published in March 23, and they specifically address meeting their Care Act duties within this particular plan. So some of you may have been party to their fair cost of care funding exercise that they did, where they asked you to submit what your costs were for placements. Now, they have said in their sustainability plan that the fair cost of care process was not intended to replace the fee setting element of local authority commissioning processes or individual contract negotiation, but the information from that cost of care exercise must be taken into account and will be a material consideration in the decision-making process. Their fair cost of care calculations state that actually, and again we're going back to 2022 because this is obviously a report that's it's maybe a little bit out of date now, that actually 28% of residential packages were paid at the council's usual rate and 54% were at or above the enhanced rate. So a fairly large proportion being paid at an enhanced rate. But in relation to the cost of care calculations exercise that was gone through a few years ago, only 85 of the 210 homes in Norfolk actually responded to the council. So for me, that raises questions about whether the figures that were presented were representative of the market costs. That represents only about 40% of the market. And when those costs were being put forward, were they actually being presented on current costs, or had all the service users been reassessed to ensure what the actual assessed cost was? As I said, the 2 years have gone by, a lot has changed, and slightly more concerning for yourselves is that Norfolk are actually facing a shortfall in budget of £44.7 million for the financial year 25-26, and apparently they have plans to save money out of the adult social care budget. So not great that £16.5 million is going to be lost from the social care budget. So what can you actually do? I'm sure obviously we've covered areas around what your rights are as providers, and I've covered areas around the wellbeing principles in relation to assessing service users. But what can you do to help service users ensure that they get correctly assessed, that their care plans are reflective of their needs, and therefore the personal budget is reflective of the needs that need to be met? Well, the first thing I would say is to ensure that you are accurately capturing service users' needs and that these are accurately recorded. We all know that there's no such thing as a uniform set of needs, but there are many times over the years that I've been doing this where I see standardised care plans. Care assessments that you undertake need to clearly set out needs and plan how these will be met, and you should be reviewing them regularly. You need to be able to demonstrate the clear picture of needs of that service user. So anybody picking the care plan up will be able to understand where they're at, where they've come from, where they're going to. Now, again, frequently in the time that I've been helping care providers, I'm surprised at how many care plans are of poor quality. They lack information, they contain wrong information, they contain conflicting information, even basics such as referring to a female as a male and vice versa. Again, if we're looking at it from a personalisation perspective, calling Betty he is not going to be standing you a very good stead to say that you've considered their care needs and their personal circumstances. When you are undertaking reviews, involve the service user and any others who may be of relevance, whether that's somebody with power of attorney, family members, and record their views. Again, frequently I see situations where care plans have been reviewed and the service user has not really been involved. It might be that your reviews are able to trigger local authority reviews to undertake the care and support plans, because care needs have moved on. There have been increasing costs in order to meet those needs. Now, of course, you do run the risk that by triggering those reviews, that it results in the local authority moving a service user. But what we're trying to understand is, or trying to achieve, is that you are demonstrating with clear documentation that someone's needs have changed and what the real costs of that of those are. When a local authority review is being undertaken, you might want to consider whether you can be present at the review, because remember, the adult can ask any person they want to be involved to be present. Of course, we've got to consider whether there's a conflict of interest here. You know the service user better than the local authority or the person coming to assess them. But we've got to make sure that, say you're not being seen to be doing this because of a financial interest. So it has to be with consent. There can't be any concerns over pressure or duress. When an assessment has been carried out by the local authority, has it taken place with the service user involvement and the relevant people that service user wants to be involved? Feed into that review with reference to your paperwork. There's the classic quote of if it's not written down, it didn't happen. You will have no proof saying to the local authority that the service user has particular needs if you cannot demonstrate that you've got a record of that. Ask questions with reference to terminology from the Care Act, the Wellbeing principles, talking around involving the service user. Encourage the service user or the advocate, whoever that might be, to ask for a copy of the care and support plan, and then hopefully can share that with you. Is that care and support plan reflective of the service user's needs, and is the personal budget clear, and is it capable of meeting those needs? Now, as I said right at the very beginning of this presentation, ultimately the challenge lies with the service user to challenge the local authority social care assessment process. But any of the stages can be challenged, whether that's the assessment, whether they've identified eligible needs properly, whether that's ensuring that the care and support plan is thorough with the right information in it, the financial assessments, or at subsequent reviews, all these elements can actually be challenged if, of course, there are grounds to do so. The Care Act itself did provide for an appeal system against social care decisions, but that part of the legislation isn't actually enforced yet, which is unfortunate. So at the moment, service users have a few options if they do wish to challenge a local authority in the way that they've carried out an assessment. They could make a complaint. They could lodge an appeal if the local authority has an appeal process specifically in relation to social care decisions. And I know that not every single local authority does. They could go to the Ombudsman, or of course there's judicial review proceedings, which are difficult, expensive, and probably of last resort. For you as providers, as I mentioned, again, you've got, in order to raise challenges around funding, then the first place to look is the contract. Whether there are options for alternative dispute resolution within the contract. We've obviously spoken about contractual failures to pay fees that have been agreed, particularly as I mentioned the Julie Richardson case. And we've obviously seen that judicial review with the Staffordshire Care Association has had some positive effects. Now, you can't make somebody contract with you, as much as we would like that to be the case. If ultimately the service user doesn't want to stay, or the local authority wants to move, and the service user is not prepared to fight, then of course we can't do very much about that. But hopefully the types of information that I've referred to today can help to improve your contractual position and understand where opportunities might exist to at least feed into the process and challenge in order to achieve a better outcome for the service user and yourself. Thank you very much. I'm happy to take questions.